About 3/4 of applications for Social Security disability are denied. If that happens to you, it doesn't mean your situation is hopeless because you can appeal. That's what I'm going to talk about in this video. Hello, I'm John Foster. I'm a medical doctor who does Social Security disability exams. I've done about 1,500, and as usual, everything I say reflects my own opinions based on my own experience and study, and not the opinions of the Social Security Administration or any other medical body. Now, if your application for disability is denied, you'll be notified with a letter. The letter will include the reasons where you were denied. It's very important to make a note of the date when you received the letter. And the reason is you have 60 days from the day you received the letter to file an appeal. If you take longer than 60 days, you'll have to resubmit your application. You'll have to start over from stage 1. So it's very important to get your application for an appeal in within 60 days. Social Security calls this a reconsideration, and what will happen is a different person in Social Security from the person who reviewed your application the first time will review your initial application and all your records and any new information or records that you send in with your appeal. There's a link to the appeals process in the description to this video below. Now, the number one reason for disability applications being denied is lack of medical records. So make absolutely sure that Social Security has all the pertinent records for your disability claim. If you're denied, likely 6 months to 12 months will have passed between when you submitted your claim and when you got denied. Any additional medical records, any doctors that you've seen, specialists, operations that you've had, surgeries or tests are all important for your appeal. And you should make sure that records for all of these things are sent into Social Security. You want to keep a record, include the name, address, phone number, fax number, and visit dates for all healthcare practitioners, the types of treatments you get, and the tests since you last sent in your disability application. And you want to send all that information to Social Security. In the application, you'll see space to indicate any new medical conditions that have developed and any changes to your medical condition. And these questions are really important. Many disabling conditions tend to get worse over time. For example, many cases of arthritis get worse over time. So there's a good chance that your condition will have become more disabling in the time between when you submitted your application and when you get your denial letter. And it's very important to communicate any changes to Social Security and be specific as you can possibly be. For example, if you have arthritis in the knees that's painful, saying my knee pain has gotten worse might help a little bit. But here would be an example of a much more specific and better reply. The painful arthritis in my knee has gotten worse since I sent in my application. At that time, I could stand for about 30 to 40 minutes before I had to sit down and rest. Now I can only stand for 15 to 20 minutes before my knee pain becomes too bad. That's a clear piece of evidence that your disabling condition has gotten worse. Another important piece of evidence is to list your medications. Medical professionals can tell a lot about a patient just from their medicines. And if you your medicines have been increased or you've been put on stronger medication, that's also an indication that your disability has gotten worse. For example, you might say, I used to take pain medicine twice a day for my knees, but the pain has gotten worse and now I have to take the medicine 4 times a day. And as I've mentioned in previous videos, if you have any side effects of medication that limit your ability to work, be sure to indicate them. For example, many pain medications cause people to become sleepy, groggy, or forgetful. Diuretics, also known as water pills, such as Lasix or furosemide, may cause you to have to take frequent bathroom breaks because you have to pee frequently. That can be a work-related limitation as well. Don't use a lot of medical terms and jargon when talking about your conditions. Imagine that you were talking to a friend or relative who had no medical knowledge and explain why you cannot work. Time and again, I see people who answer these disability questions as if they didn't put any effort into them at all. And I can't help but think that limits their chances of getting approved. For example, in the initial application, Social Security asks, how do your illnesses, injuries, or conditions limit your ability to work? Well, here's a real example that I read yesterday. The patient wrote, a lot. It's my legs. Can you figure out if that person is disabled or not from that answer? I sure can't. What's up with their legs? Are they painful? Are they weak? Are they numb? Do they give way? I haven't a clue, and neither does the person at Social Security who reviewed that answer. Make your limitations clear. Another vague answer I get all the time is, I can't walk very far. I have no idea what is far for you. Frequently people will say, I can only walk to my mailbox and back. Well, is your mailbox on your front porch, or is it 1/8 of a mile away down a long country driveway? I measured mine. It's 190 feet from my front door, but I don't know the distance for your mailbox. Find out. Finally, make sure all the forms are filled out legibly. Typing is by far the best. You can fill out the forms online, in which case they will be typed, or you can print them out and fill them out and mail them in. If you fill them out printed, be sure to type them. If you can't type, get somebody to type for you. And when you mail the forms in, go to the post office and send them certified mail, return receipt requested. Now the bad news is written appeals only get approved about 10% of the time. They have a low approval rate, but you still shouldn't give up if you feel that you're disabled. You should appeal a second time. Again, this must be done within 60 days or you'll have to start all over again. When you appeal the second time, you get a hearing by an administrative law judge. That used to be done in a courtroom, but now it's mostly done over Zoom. And the good news is almost half of the hearings by administrative law judges are approved. And I think that's probably because the judge can actually see you and you can describe your problems yourself, which is a lot different from reading questions to a form. If an administrative law judge denies your claim, you can actually request a third review by an appeals counsel, and if that's denied, you can request a federal court review. I've never been involved in any of the latter two, and I really don't know anything about them. Now, one question is, should you get an attorney if you don't have one and your claim is denied? For a written appeal, I would say possibly. And I'm not an attorney, so don't take legal advice from me. But I think you should give it serious consideration. For a hearing before an administrative law judge, I personally would never go into a court case without the assistance of an attorney. I think it's essential. Well, I hope this has been helpful, and as always, remember, if it happens, it's possible.